You are most welcome. Thank you very much for coming to appear before the committee today. We've got quite a lot of ground to cover, so succinct answers would be exceedingly helpful. Can I begin by asking you, you have in the very helpful paper that you've written talked about the docking solution to the question of how we might potentially come up with an arbitration mechanism. It'd be very helpful, I think, for the committee if you could just set out briefly for us how that would work and why you think it might provide a solution.
Thank you very much, Mr. Chairman. Ladies and gentlemen, thank you for having invited me and being prepared to listen to me. Let me make one preliminary statement. What I'm saying here are my own views.
Indeed.
They are not the views of the EFTA Court. The EFTA Court doesn't have a view on all these matters. But they are still the views of a decision maker and not just of an observer. I have participated in some 260 cases and I have acted as a judge rapporteur in many of the EFTA Court's landmark cases. Now, concerning docking, docking was an idea that was proposed to Switzerland by the European Union in 2012-2013. It was meant to give Switzerland the possibility to subject its bilateral treaties with the European Union to the jurisdiction of the EFTA Court and to the competence of the EFTA Surveillance Authority. That would have meant that Switzerland wouldn't have had to take the whole EEA acquis. In fact, Switzerland doesn't have an agreement on services, they don't have an agreement on establishment, they don't have an agreement on capital, they don't have common competition rules, they don't have common state aid rules, and yet they were proposed to negotiate with the Norwegians, with the Icelanders and with the Liechtensteiners whether they could dock to the two institutions of the EFTA pillar. Obviously, the Union also would have claimed the same, but since they made the proposal, it was quite clear that the Union was positive about that.
Thank you very much indeed. Christopher Chope.
So why was the Union positive about that?
You know, the Union, Switzerland has a peculiar history in European integration, as you are aware. In 1992, the Swiss signed the EEA agreement, but after a negative referendum, they were not able to ratify it. And then Switzerland and Switzerland's industry lacked access to the single market, so they negotiated bilateral market access treaties. That was quite burdensome, and it took a long time, and there were 10 years where Switzerland was with zero growth, and a lot of economists, I'm not an economist, but I can read what they say, linked that to the lack of access to the single market. And then after a few years, in 2008, the Union said to Switzerland, now you have so many bilateral treaties that, in fact, you are a hidden passenger, so to speak, in this single market. And we cannot go on with these diplomatic dispute resolution committees anymore because they are not fast enough and they do not provide enough legal certainty, so you must recognize a court mechanism. And then the Swiss had difficulties, to familiarize themselves with this idea, and at the end the Union said to them, why don't you make a second attempt to join the EEA as a full-fledged member? And the Swiss said, no, we don't want this. And then the Union said, then you could dock. That was the background.
So how realistic do you think it is that the United Kingdom could join EFTA but not the EEA, and would it then be able to engage in the docking which you've described?
Docking is largely uncharted terrain. What we know about docking are these documents from 2012, 2013. On the one hand, there are a couple of government reports of the Swiss government where this is mentioned. There is an expert opinion of an elderly public international law professor from Zurich University which discusses it, and there is this famous non-paper which has been drawn up by the chief negotiators of the Union and of Switzerland in May 2013. This non-paper is officially still secret, although almost everybody knows what is written in there. This is what we know about docking, but I mean, it would essentially be for negotiation to find out how far you can go. What I find interesting is that in a presentation of 19th of January of this year, docking is also mentioned by the group headed by Mr. Barnier.
I see. So you're saying the EU is almost encouraging the United Kingdom to adopt a Swiss model to join EFTA but not the EEA?
Well, EFTA is another matter. Docking would be a partial participation in the EEA. EFTA is something else. But I cannot say they are encouraging, but the sheer fact that EU people are thinking about keeping Britain in the single market by way of using these EFTA pillar institutions indicates to me that they imply this, because they must be aware of the fact that full-fledged free movement of persons is for Britain a political difficulty. I think they are aware of this, and yet they are discussing this.
Thank you.
Thank you. Emma Reynolds.
Following on from that, but from an EFTA point of view, if the UK were to join the EFTA court, what impact would it have on the court? What would be the benefits to the court or the disadvantages?
The benefit for the court, I have been a judge for 22 and a half years, and the last 15 years I have been the president of this court. And I give you my personal view on this. The benefit for the court clearly would be that it would become more important. I mean, I always felt that it was an important court, but it is still the court of 3 small countries. And with a member state of the size and the power of the UK, this clearly would be an interesting option from my perspective.
Okay. You have suggested that the EFTA states and the EFTA court have more sovereignty than the parallel in the EU and the European Court of Justice. Can you explain why that is the case?
Yeah, the sovereignty issue was dear to the heart, in particular, of the Nordic EEA-EFTA states, because they come from a very dualistic tradition when it comes to constitutional law. And so they wanted to avoid, for instance, that the EEA agreement would produce direct effect. In fact, there is a protocol, Protocol 35, and the EFTA court has given interpretation to that protocol where we said no direct effect and no primacy. In addition to that, the Supreme Courts in the EFTA states have more sovereignty than the Supreme Courts in the EU member states, because there is no written obligation on them to refer an unclear question of EEA law to the EFTA court. In my capacity as the president of the EFTA court, I have always criticized this, but it remains a fact. In addition to that, our preliminary rulings are, strictly speaking, not binding on the national court. They are advisory opinions. In reality, they are some sort of sui generis rulings. The national court is not absolutely free to follow or not, because if they were not to follow, they may run into difficulties from the perspective of homogeneity and of this country's obligations under the EEA agreement. But that is very difficult to enforce. At the end of the day, it's quite clear, and both the Supreme Court of Iceland and of Norway have stated that they take our opinions very seriously, but at the same time, they are not only entitled but also obliged under national law to assess independently whether they will follow them.
Okay. Is it the case that the EFTA Court and the European Court of Justice are more equal than many suggest? And under the two-pillar system, what would happen if the two courts gave conflicting interpretations of the law? And have there been any instances of this?
Yes, well, that's a very crucial question, and it's a very fair question. And I probably have to distinguish here. I was a professor at the University of Texas for quite some time. Distinguish, as the American legal realists do, between the law and the book and the law in action. When these provisions were drafted in 1991-92, everything was done in order to keep the ECJ happy. The ECJ was very reluctant to accept another court on the European scene, which would give interpretation to law, which is a separate legal order, but still identical in substance to EU law. And so the written rules say basically the EFTA court shall either follow or take into account relevant ECJ case law. That was written, and that has also then prompted the ECJ to say in his second EA opinion, we approve this court system, this is okay with us. Now, in reality, things have developed in a quite different way. First of all, because unlike what the drafters have assumed, it's not so that new legal questions go to the ECJ first. In most cases of the EFTA court, we had to tackle new legal questions where there was no answer by the ECJ in the past. So that was already a totally different ballgame, and the question then arose whether the ECJ would follow us and would take us into account. And in fact, there is a very intense judicial dialogue going on between the two courts where the ECJ is following us in many, many cases. This has been admitted by my counterparts, or now since 1 month former counterparts in the presidency of the ECJ on many occasions. If the ECJ goes first, then we would, under the homogeneity rules, follow the ECJ. I mean, it is not a purpose of this whole exercise to deviate good. But nevertheless, in a number of cases, the EFTA court felt that having assessed the facts and having assessed the law, we could go another way. And we have done that. And then it is possible that in the future the ECJ will follow us. It is also possible, and it has happened, even happened in a case concerning food law, that we did not follow the ECJ, and the ECJ then later overruled its previous case law and followed us. That's probably the most important case. That was this Kellogg's cornflakes case. And there have been a number of other cases, for instance, when it came to taxation issues, or when it came to national gambling monopolies, or when it came to the legal nature of a website, that the ECJ would at first not follow us, but then when they had a second or third chance, they would put themselves in line with us. So at the end of the day, it then boils down to the more theoretical question, could there be some kind of an open clash, and what would happen in case of an open clash? The treaty says there are dispute resolution provisions for this. These provisions have been written by diplomats, and if you read them, you can feel that they are more theoretical. In practice, they are hardly operational. It has been alleged in letters to the editor and in articles in the Financial Times in particular by a former high official of the European Union that if there would be a conflict, the ECJ would prevail. But there are no easy answers for this. At the end of the day, in theory, the matter could be submitted to the ECJ, but in order for it to be submitted, the EFTA states would have to agree. It's politically difficult to imagine that the EFTA states would agree that the matter goes to the court of the other side, which has already, uttered a view on the question. Then the second possibility, the treaty says that the joint committee, which is a diplomatic body, will take care of the thing. And there this gentleman, this former high EU official says, well, the joint committee could then overrule the EFTA court judgment. Ladies and gentlemen, I find that's a pretty outrageous statement. This smells totalitarian. that 3 diplomats could overrule the judgment of an independent court of law would go against any tradition of Western civilization. You know, you had the Settlement Act in 1701 when Britain, as the first country in Europe, recognized judicial independence, at least to a certain extent. And in my view, that's totally out of the question. So the third possibility which is mentioned in the treaty would be sanctions. But if it comes to sanctions, then it's already very difficult. You know, then the basis for a good cooperation would already be lacking. So I think both sides would think twice before they would impose sanctions because of a ruling of an independent court of law. And if we look at now the development and also what has been stated by my friends from the ECJ on numerous occasions, the most sustainable mechanism is judicial dialogue, as I have described it. We may change our case law and follow them, but they may also change their case law and follow us. And looking back these 22 years and having in mind how small we are right now at the EFTA Court, I think it has worked out in a remarkable way.
One last question. Take you back to the UK. It was agreed in December that as a last resort, in order to avoid a visible hard border on the island of Ireland, that the UK might agree to regulatory alignment in certain areas. And some people have suggested that we should have regulatory alignment on a wider basis in order to have access to EU markets. If we didn't join the EFTA Court, what other options of arbitration are available to the UK and the EU?
Yes. I think I have set this out in the paper I sent you. I have difficulties to see a good mechanism of arbitration if you want to stay in the single market. If you want to leave the single market, that's another matter. But if you want to stay in the single market, diplomacy will not fly, because the Swiss have been told in 2008 it's over with diplomacy. The Swiss have not been able to conclude one single new market access agreement since 2008, although there is at least one agreement which is fully negotiated and ready for signature in the field of trade in electricity. Arbitration has been rejected by the European Union in the case of Switzerland. The Swiss tried that for decades. And it is even said in Article 111, Paragraph 3 of the EA Agreement, arbitration can only be held, if at all, on sanctions, on the appropriateness of sanctions, but never on substantive EA law. And in my view, this provision has a precedential character also for other countries which would like to, stay in the single market in one way or the other. Bilateral court, UK-EU, there the Swiss government sent a letter to the EU Commission in June 2012. I'm sorry. No, bilateral court, UK-EU, in my view, is excluded because this court would be above the ECJ. A UK court above the Supreme Court, there the Swiss tried in 2012, was rejected. The ECJ is apparently a no solution anymore for Her Majesty's government. Then we have the Ukraine model, which foresees an arbitration tribunal, but every question of European law must be referred to the ECJ, but would decide in a binding way. So there are two options left, either the EFTA court in one form or the other, or another court modelled on the EFTA court. There I may refer to this Bruegel paper, which discusses this partnership idea, but I think it's quite natural that such a court would have to be a multilateral court. There couldn't be just a UK court.
Okay.
Thank you.
Thank you very much indeed. Richard Graham.
Thank you very much. Professor Beidenbacher, can you just confirm for us that if we, the UK, wanted to consider the EFTA court for docking, then we would firstly have to apply to be a member of EFTA, and secondly, if that was accepted, would we have to apply to use the EFTA court as a form of docking mechanism in the case of disputes with the ECJ?
Well, not disputes with the ECJ, disputes under your agreements.
Yeah.
But as regards your first question, whether EFTA membership would be required in order to dock, that is an unresolved question. I mean, normally you would assume yes, because this is a whole EFTA thing, but it is written nowhere that EFTA membership would be required. You would need the consent of the European Union, and you would need the consent of Norway, Iceland, and Liechtenstein. But whether the Swiss would have a say in this, in my view, is not decided.
Right. And if, hypothetically, it was agreed that Britain could dock with the EFTA court, would that automatically assume that a British judge, or more than one British judge, would also be part of the EFTA court?
I think that was the idea when this docking solution was proposed to Switzerland in 2012, 2013, that a Swiss judge would then become part of the EFTA court and the Swiss college member would become part of the EFTA Surveillance Authority.
And in your opinion, would the European Union be likely to accept the EFTA court as the arbitrator of any disputes between the UK and the EU?
Well, as I said, given the fact that docking is mentioned in this document of the Commission, I must assume that, at least implicitly, they have been thinking about it. I'm sure they have been chasing every idea and also been looking into the details. That's, at least in my experience, how the Commission works.
Just one very important point comes further.
Craig, of course.
Professor, did I hear you say correctly that should we wish to take this route of EFTA membership, that it would require the permission of the EU?
No, not EFTA membership. EFTA membership, there the EU has no say. For EFTA membership, you would need 4 votes.
Yes.
The 3 plus Switzerland. But this in itself...
And EEA membership?
Then the EU would have a vote.
The EU has a say.
Yes, because the EU is a contracting party to the EEA agreement.
Right.
But EFTA membership would provide you with the opportunity to enter the free trade network of the EFTA states with the rest of the world.
Thank you very much.
Thank you. Stephen Kinnock.
Thank you very much, Chair, and hello, Professor. I was wondering if you could give a sense of the role that the overall objectives of the EU treaties as compared to the EEA agreement play in the way in which the EFTA Arbitration Court interprets and acts as contrasted with the European Court of Justice. So obviously the overarching aim in the EU treaties is ever closer union of the peoples, whereas Article 1 of the EEA agreement is far more focused really on commercial engagement and the market. So it's very much about I would probably say the way in which the internal market was originally conceived in the 1980s as compared to a much deeper and closer union that has evolved since then. What role does that play in terms of influencing the mindset of the EFTA Court as contrasted with the European Court of Justice?
Thank you very much. Let me say first that the EA agreement is a single market agreement. It has no goal of creating an ever closer union.
Yeah.
Political integration is basically excluded. That means, first of all, that the common policies are also excluded. I want to emphasize this. Agriculture, fisheries, foreign trade, foreign policy, and so on are excluded. I mean, when we talk about fisheries, I just read the other day, about this snow crab case. That snow crabs are very expensive seafood, and And EU vessels wanted to catch them in the waters around Svalbard, in the north, near Spitsbergen. And the EFTA Surveillance Authority said, no, it's not possible. This is for us. And we were also very strict, in saying the catch of fish is outside of the scope of the EEA agreement. Now, when it comes to your question of how this impacts the case law of the EFTA Court, first of all, the EFTA Court has been very strict in defining the outer boundaries of the agreement when it comes to agriculture and fishery. There we did not compromise. When it comes now to the interpretation, for instance, of free movement of goods or of competition law or of all sorts of secondary law, I can give you a few examples where I think we were rather market-oriented. And when I say market-oriented, that doesn't mean that we were antisocial, not at all. Market-oriented means rather that we were critical of mercantilism and of protectionism. For instance, this case about the Kellogg's cornflakes, we didn't buy the argument by one of our governments that they see to it that the children in school get enough iron every morning because they give them a piece of cheese fortified with iron, and once they have enough iron, they must not eat these Kellogg's cornflakes anymore. That is a paternalistic approach, and we said no way. And the ECJ then even overruled its previous case law in light of this liberal approach by the EFTA Court. We have quite clearly said...
Sorry, just quick.
Yes?
The ECJ overruled
its own
on the basis of advice from the EFTA Court.
Of us. That was in the early days. We were quoted 6 times in this judgment. Normally, we opened a bottle of champagne when they quoted us, but that time we couldn't do it. It would have been too much.
Then, called Kellogg's instead.
When it comes to the judicial review of competition fines, the UK is a leading country when it comes to competition law and practice and economics. The allegation of practitioners until today is that in the European Union, the Commission still enjoys quite a margin of appreciation when assessing questions, complex economic questions. Whereas we said there must be full judicial review of competition fines because we are talking about hundreds of millions and billions now here today. Or, for instance, a famous question whether an in-house counsel should be excluded from representing the own company, where our sister court said in-house counsel are, by definition, always not independent. And that's why they can never represent the company. We said we have to look at the case at hand and the concrete circumstances. If the in-house counsel is independent, then it's okay. It's also a cost-saving measure, and it is in the interest of fostering compliance that in-house counsel are not excluded here. There have been other cases in which I think at the end of the day we have been rather market-oriented. Let me give you an example which concerns the United Kingdom rather directly. Last October, we were faced with the question of whether a public authority should be held liable under normal tort rules or under state liability rules if it has awarded a public contract to the wrong bidder. That often occurs, that the best bidder doesn't get the contract, but somebody else for any kind of reasons. And the question is then, if the bidder who deserved to obtain the contract but did not get it wants to sue for damages, how high is the threshold for this lawsuit? And there the ECJ came up within 2 months with 2 conflicting judgments. One chamber said it is a tort law, simple tort law case, and the other chamber said, no, since the state is involved, it's a state liability case, which means that the firm which suffered damage would have huge difficulties. to obtain compensation. And in this situation, we said a simple breach must be sufficient. A simple breach must be sufficient because in such a case, the state does not act by state authority. It's a simple participant in the commercial business. So that's clearly a market orientation. And the link to the United Kingdom here is that the UK Supreme Court in April of last year had exactly this question. And they said, well, we see these two conflicting ECJ judgments. We give interpretation to these two, and we think that the one which goes for state liability is the more convincing one. So they overruled their own case law. This is one of the most fundamental questions of modern economic law, because we are talking about huge, huge amounts of money which are at stake here. And at the end of the day, this is not only about a non-mercantilist model, it is also about avoiding moral hazard. Because if a civil servant does not risk, that something is going to be, held against him, at the end of the day, they can easily give the contract to this and to that. And so, I mean, it's a very, very fundamental question.
Thank you very much. You've talked a lot about this issue of the potential conflict between ECJ and EFTA Court, and you've pointed out that you were quite surprised that the British government's paper on dispute resolution only refers to the written law and doesn't really refer to the sort of continuous dialogue that a number of other eminent lawyers have talked about in terms of the relationship between the EFTA Court and the ECJ. Can you say a bit more? Why do you think that the British government's obviously you can't speak on behalf of the British government, but could you expand on why you think that was a missed opportunity in that dispute resolution paper not to talk more extensively outside the confines of written law?
Yes. Well, I can only guess here, but I have had years of experience with the Swiss government. I'm the Liechtenstein judge, but I'm a Swiss national, and I've been a professor in Switzerland for decades, so I'm very familiar with the Swiss situation. In the case of Switzerland, it was the same. It is very difficult and burdensome to read judgments and to compare them. It's much easier to have a look at the treaty and to say, well, there is stated, this is one-sided. To analyze a case law is quite a challenging thing. And that would be my answer, that people don't make the effort to really look into these matters. It was the same in Switzerland.
So you think it would be a good idea in terms of our debate here in this country, to get a better understanding of the dynamics of the interaction between the courts, because at the moment you feel that it's insufficient. We don't have a sufficient understanding of how it really works in practice.
Well, it is a complex thing. It is, I admit, that's not easy. You have to invest a lot of time and you have to be experienced in this. And part of my showing up here today is my preparedness to explain these matters. Now, I'm not absolutely free to speak about it, but I'm outgoing as a judge, and I will continue to deal with these questions. I mean, at the end of the day, there have always been two structures in Europe since 1960, even under the OEEC in the 1950s. There were these two movements, those who wanted to go for political integration, at the time the Six, and then the Brits and the Swiss, who were reluctant and were hoping that this schism could be avoided in the 1950s. Then the European Economic Community was set up in 1957, started in 1958. In 1960, Great Britain then took the initiative to set up EFTA with those who didn't want to join the community at the time. It was the time of the inner six and the outer seven. And in one way or the other, this way of thinking in categories of free trade and the like has always been there, although most EFTA states joined the European Union then in the meantime. But there is always this, separation between the way of thinking of those further north and those further south. And it probably has to do also with, theory of legal origin and with religion and the like, Geneva is located in Switzerland, was the place where Calvin started his Reformation, which then moved over parts of what is now the United Kingdom also to the United States. And the approach to the economy of the Swiss or of the Brits, if I may now say in this general way of the Americans, is a different one than the approach to money by the people further south in Europe.
Thank you.
Okay.
Thank you, Joe.
Now, I've got Joanna.
Can I ask you this, Professor? One of the big concerns in the negotiations between the EU 27 and the United Kingdom has been ongoing protection of the rights of EU citizens living in the UK and the rights of UK citizens who are also EU citizens living in other EU countries. Now, as I understand it, the concept of EU citizenship is very much a concept of the European Union and not one which really exists in the European Economic Area. Can you tell us what role, if any, the concept of citizenship and the protection of citizenship rights plays in the jurisprudence of the EFTA Court?
Yes. Well, we had a number of cases involving this citizenship directive. It has been taken over into the EEA agreement by way of a compromise. That means the economic rights derived from citizenship have, as a matter of principle, been taken over, but not the political rights. The EFTA Court did not, in my view, not have the right case so far in order to, really make a elaborate judgment. We had this case of this gentleman from an African country, I don't recall where from, who had married a Norwegian woman while living in Spain, and then the couple wanted to move to Norway, and they were denied access to Norway, and the EFTA Court then, by way of probably filling a gap, judges do that from time to time, that they assume that there's a gap in the law, and then they think they are entitled to fill it, a lacuna. We ruled that this gentleman would have access to Norway. It was a case which has been blown up by a lot of people in Norway who do not like the EFTA Court. At the end of the day, the case is as it is, and I would say no general conclusions can be drawn from this case. I mean, in the case, it was just a matter of reasonableness and of decency, in our view, to give this woman the possibility to keep her husband with her. I also remember that in the oral hearing, I asked the Norwegian government, is there any indication of an abuse of law here? And they said no indication of abuse. And if I remember correctly, we even wrote this into the judgment in the paragraph. So there is the reservation of there being an abuse, but you cannot just claim an abuse, you have to prove it.
You see, what I'm really getting at is your former colleague and no doubt very good friend, the Right Honourable Professor Sir David Edward, has also, former judge at the Court of Justice, has also been very critical of the UK government's enforcement and dispute resolution paper, because he felt that what the UK government were focusing on was very much EU law resolving disputes between member states and the EU. But Sir David pointed out that a huge aspect of EU law and the jurisprudence of the Court of Justice is about protecting the rights of individual citizens. Can the same be said of the EFTA Court?
Well, I mean, the EEA agreement is also a treaty which gives an active role to private operators. Not to the same extent as in the European Union, because as I explained, they don't have a secured access to the EFTA Court, unlike in the European Union, but private operators play an important role. And the EFTA Court has tried, to strengthen the position of private operators, not least because in academic circles, for instance in Oslo, there was a tendency to claim that the A agreement is at the end of the day a pure agreement on the public international law, which would then mean that it binds essentially the states, and what is left for the private people is more or less a reflex protection. So at the end of the day, yes, I would say we also give protection to individual operators, but not to the same extent as in the European Union.
Thank you.
Jeremy Lefroy.
Thank you very much, Professor. There has been some concern mentioned to our committee about the position of nationals in the EEA states, and indeed who are living in the UK, and UK nationals living in the EEA states, and of course Switzerland, effectively the EFTA states, that the whole discussion has been between the UK and the EU and their citizens, and the position of Norwegians, Swiss, Liechtensteiners and Icelanders in the UK and vice versa has not been taken into account. Is that something that you or the court are concerned about?
No, the court is only concerned about the cases which are being brought before it. And this is a political issue, quite clearly. If the EFTA states have this feeling, then they have to do something about it, but I cannot make a statement.
You have not heard anything of that yourself?
Yeah, as a private citizen, yes, I have.
You have. Thank you.
Sorry.
Thank you.
Stephen Timms.
Can I just ask you to expand briefly on a point you made a couple of minutes ago? This is a theological question. You suggested the approach of the EFTA Court kind of reflects the teaching of Calvin. Just tell us a little bit more about what in Calvin's teaching is reflected in what the EFTA Court does.
No, I didn't say that. What I wanted to indicate is that there are certain differences in the way people further north think about how to manage a state and how to manage an economy as compared to people further south. And that may have to do, to a certain extent, with Calvinism, because Calvinism, at the end of the day, taught people that, to be wealthy and to be successful on earth is a good thing, because God will be pleased by that. Whereas other religions didn't have this approach, and I think you can see that in the way, in these countries you address the issues. If I am correct, there is no notion of state in the Hegelian way in Great Britain as it is in Germany. There's no nation of la nation avec toute sa grandeur like in France. In Britain, it's a rather sober approach. You need a state in order, to regulate certain business, and at the end of the day, they sit in for civil society and for the social partners to figure out what is the best for them. I may remind you that Napoleon, allegedly it was Napoleon, made fun of Britain by calling the Brits a nation of shopkeepers, and the Swiss. There was this. Is this because of me? No,
no, it's not.
And Voltaire wrote about the Swiss bankers. If you see a Swiss banker jumping out of the window, follow him. You can sure that there's some gain you can make. It's a different approach to dealing with the economy.
Thank you.
Craig McKinley.
Yeah, thank you very much. If I can come back just with a very small point. There's been discussion this last week that if we try and cut and paste some of the existing EU FTAs, and we cut out the EU and we put in UK, there's been discussions, we don't know how true it is, that some of the countries may wish to not just be accepting of as a cut and paste, they may want to change it before they'd allow a continuing FTA with the UK. should the UK join EFTA and be approved by the others, would we be then immediately a party to the EFTA's FTAs with no further complaint by the other contracting countries?
Thank you for this question. This is essentially a question which is beyond my competence. I mean, I think I know that in certain of EFTA's free trade agreements there are clauses
which allow extras,
which address this problem.
Thank you.
Well, when it comes to quota or the like, you will still have to negotiate then. But essentially, I think it is foreseen in certain agreements that others may sneak in.
Right. Well, that is, I think, concludes the session.
Mr. Chairman,
yes.
You know what I brought with me? I found this by coincidence. A former lawyer in my cabinet, a Swedish professor, has published a very short paper on the situation at the border between Norway and Sweden, and says this could be an inspiration for the Irish issue. May I give the committee this little paper?
You certainly may, and we look forward to reading it. And on behalf of the whole committee, can I thank you very much indeed, Professor Badenbacher, for coming to give evidence today. We appreciate it. It was a great pleasure to meet you last year, and you certainly helped us in our deliberations. Order, order. That concludes the session.
The proceeding has ended. 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 The proceeding has ended.